Hello, everyone, and welcome back to Immigration Talk Show. I'm Nipasa, and I'm going to be your host for this session that's lined up. And before we head on with today's discussion and we have our guest join us, I have this important disclaimer. And that is by watching all our videos, you understand and agree that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use at your own risk. Well, thank you so much, everyone, for joining us. And absolutely, like I said, we are going to be joined by a guest for today, and we're going to be discussing on preparing for the unexpected. What happens during an H-1B work site inspection? So, yes, we're going to talk about different site visits and how it going to affect and how to prepare ourselves for it as well. And to help us through all of that and dive deeper into this topic, we've got none other than attorney Justin Rivera from Wasden Immigration Litigation join us. So please help me welcome him once again. Hi, Justin. How are you doing today?
Okay, it's a Friday, so going into a long weekend, so that's always nice. But yeah, I'm doing well. How are you doing?
Doing good too. And I'm excited to, yes, the long weekend. Memorial Day, right? Monday is also going to be a holiday, I think.
Yeah, that's correct.
Absolutely. So I'm excited for today's session, and this is going to be a good one because everybody they have been very concerned about site visits and how to prepare themselves, whether to answer or not to answer. So a lot of questions from my end, and I'm expecting folks out there to also participate with their questions. And let me tell all you folks out there, all the viewers watching us right now, you can join us by commenting wherever you're watching. Our handle is at Immigration Talk Show on YouTube. You can share this with your friends and folks who can also join us. And another best thing is you can call us on this number. So dial this number to join us on call, and the number is 425-436-6335, and the access code is 988-888. So I think, Justin, let's waste no more time and go directly into the questions, if that's fine.
Yeah, absolutely.
All right. So this first question I have for you is, what are some common reasons that trigger an H-1B worksite inspection?
So when it comes to worksite inspections, they're done by FDNS. FDNS is the Fraud Detection Division of USCIS, and they have the ability to do random site visits, and they do enforce random site visits, but they also have the ability to do a targeted site visit where they basically say, we have procured some information that leads us to believe that there should be additional inquiries made into this organization or this individual petition. So, how that can happen is a candidate could be going for a visa interview at a consulate, the U.S. consulate, and make a statement that the consular officer thinks is odd or off. And then that individual, the consular officer, will basically write up a report where they make a recommendation to FDNS to proceed with an investigation. So that way that would work. Like, let's give an example. Let's say candidate A, he goes to the consulate abroad. He's going for an H-1B visa interview. During the H-1B visa interview, candidate A is asked, where are you working? And he says, oh, I work in-house with my company. And they go, okay, well, what do you do? Like, what is it that's being done in-house? And he goes, well, I work on Project A. And they go, okay, well, can you show anything, any proof that you've worked on Project A, or what is Project A? And the guy gives some sort of answer that's like it's not a passing muster for the consular officer. So the officer could give the person a 221G or a visa refusal, or they could even approve the visa. But after that conversation, the officer has the ability to write a report, and that report basically will contain information like individual claims to be working in-house on Project A. Project A is not well defined. Look into. Okay, now the case moves over to FDNS. FDNS is going to have the ability to say, okay, let's look at everyone who has a petition filed with this company that says they work at Project A. They work on Project A in-house. Let's pick a couple of them and do site visits. And so now you've opened up this investigation with FDNS where they're targeting a specific thing. They're not going to tell you that. You're never going to be given the justification as to why the site visit is occurring. That is all behind the scenes. And in fact, they're going to do is say, we're doing a site visit. Sorry, I had a piece of hair on me that I thought was a bug. They're going to do the site visit saying this is a random site visit. It's just a site visit that, we're doing because you were randomly selected. That's not true. They already have something that's giving them a justification for the site visit. And so what they're trying to do is work backwards from that to find a reason why there's an issue with the petition. And the name of the game is fraud. They have extrapolated the definition of fraud to basically include any deficiency in a petition. So what do I mean by any deficiency in a petition? Okay. LCA says you're going to be working in Austin, Texas. Site visit happens. You're actually in Dallas, Texas. Well, before, that's a violation of the LCA, which totally actionable from the perspective of saying violation of the LCA, we're going to issue a notice of intent to revoke, saying that the LCA is deficient. Well, before this administration, that's probably the end of it. You file an amendment to get the petition corrected. They send it in OIR. You let them know you've corrected the petition. They'll probably revoke the previous one. Maybe you see some small issues with the amendment. It depends. Now, instead of issuing an NOIR where they're saying, hey, the LCA is not in compliance, they're going to issue that, and then they're going to say under it, statements of facts were not true. And what they're going to allege is you committed fraud or misrepresentation because this person's not working where you said that they did. And I want to really, really suss out the difference here in what is being done. Beforehand, if they revoke your petition, that H-1B is revoked. But the revocation just basically means you can't work subject to that petition. You could still work subject to another petition that's subsequently filed and approved. Now, if they're putting fraud or misrepresentation in your record, and the NOIR, the revocation occurs, and the revocation notice includes that language saying fraud or misrepresentation. Well, now you have a company that has a taint of fraud or misrepresentation on them that is probably going to follow them on any subsequent petitions that they file. It's definitely going to be something that is kept within USCIS's records and database. They're going to always have a record of the petitioner and that instance of alleged fraud. It's also going to be an issue for the employee because if the employee has a fraud finding placed on their record, that finding carries with it an inadmissibility bar. That inadmissibility bar previously was something that was going to come up when the individual goes to adjust status or when they go to apply for a visa at the consulate. Those are each times where that issue could occur. Now we're seeing USCIS is bringing up this bar on any subsequent filing that occurs in the United States. Meaning, you file an extension. They say you can't qualify for an extension. You're inadmissible because of this fraud finding. You file a change of status. Same thing. And of course, you go to adjust and you have that same issue. So it's a very serious thing that can occur. And it is being wielded in a much more liberal way than it was prior to this administration. Hopefully that answered the question.
Well, thank you so much, Justin, for that. And really, I mean, it's crazy because, yes, there's a lot of fraudulent activities, and, USCIS and the whole immigration system, they're trying to check it. One step at a time, it's happening, but there's still so much more. So we really hope that this gets, we all wish that it gets done off as soon as possible. So don't know when can that happen, but yes, thank you. And hi to Ricky. Thank you so much for joining us here on YouTube. We're looking forward for your question as well, so please feel free to ask your question. So now, Justin, this next question is: can USCIS show up for an inspection without giving any prior notice, and how should a company prepare for that?
So yeah, they can show up without notice and they can show up with notice. Usually if they give notice, it's going to be 48 hours out. They're going to basically say, hey, here's an email. I want you to send me the following documents and I'm going to come talk to you within 48 hours. And the goal of that is you're, as the employer and employee, you are intimidated. You are given a short timeline and you freak out and you hand over everything that's asked for without stopping to make a consideration about whether or not the things that they're asking for are things that they're actually eligible to request. Because what they do is what they do is they basically say, you have to participate in an FDNS investigation now. It's mandatory as of the January regulatory changes. But participation is not the end all be all, meaning that everything that is requested has to be furbished. There has to be a rational connection between the petition that is being reviewed and the information being requested by the officer. So I'll give you an example. A lot of times the officers like to use the site visit and the subsequent communication with the employer as a fishing tactic, basically an opportunity for them to go on a fishing expedition where they say, we're going to open your books and we want to look at everything that you got. We want all your payroll records for all your employees. We want a copy of every LCA you filed. We want all your petitions. We want everything. Well, at the end of the day, the purpose of the site visit is supposed to be to verify the information that's provided within the petition. So that should be the limit of the scope of the investigation. And most times, if you're not repped by an attorney, they're going to push as much as they can to get as much information as they can. You have to understand, their end game is to prove fraud. The more they prove fraud, the more they justify their budget, their existence. And so their end goal is they want that. They want to be able to show fraud or misrepresentation. And there are plenty of officers that I have dealt with personally who are going to intimidate and bully and try to force people through threats of coercion into getting what they're requesting, even if it's outside their scope. On the other side of that, there are the officers who act like they're your friend, who say, "Hey, I'm just doing my job. I'm just doing my job, and this is my job, and I'm not trying to do anything. We're not trying to prove anything. We're not. There's no intent here. There's no malicious intent. It's just a routine inspection check. Like, don't worry about it. Hand me over the stuff, and nothing will happen to you." And those officers are just as dangerous, if not more so, than the ones that are blunt about what they're doing. In order to prepare for a site visit, you really have two courses of action, one being significantly better than the other, in my opinion. One, you need to make sure that your employee, if they're working at a client location, knows who the individuals are that they are supposed to say, that's my direct supervisor or my in-client supervisor. This is my employer supervisor. If there's a vendor involved, maybe that information. There needs to be a clear chain. The other thing is, obviously, what they're doing needs to correspond to what's in the petition. If it's not, then you're already in trouble out the gate. So that's option one, where you say, all right, we're just going to make sure that he's working where we said he's working. He's doing what we said he's doing. He knows who he reports to. Those are the basic kind of questions. The better option is you give your employee and your employer, you make sure that they have a G28, that they're represented by counsel, and that the G28 is the only thing that is handed over to the officer when the officer shows up. At that point, you just say, look, I'm represented by legal counsel. My counsel will be the person who funnels all this information, and we can correspond moving forward via email or set up a phone call. What that does is two things. It alerts the officer to the fact that you have representation, which blocks them from being able to continue speaking to you. Secondly, it gives time. Instead of them just rattling off a laundry list of things that they're saying that you need to produce, give me this, give me that, give me this, you have a lawyer there who can actually sit and go through and say, well, that makes sense, that's fine, that doesn't make sense, we are not going to produce that. And the difference there is colossal, because if you're repped by an attorney, there's someone there who you are entitled to have who's going to be representing your interest. Remember, like the hypothetical I said with the guy that's saying he's your buddy, that's the FDNS officer, the guy's not your buddy. That guy's end game, the job that they do, is to get your petition revoked. That's the ultimate goal. It is not for them to show up and say, well, there's nothing to see here, I've done my job. It is to get petitions revoked. And so without representation, you're putting yourself at a pretty colossal disadvantage. But if you're not going to use representation, then what you really need to make sure you're doing is, who is the person that the officer is supposed to be directed to speak to? What are the job duties the person's doing? And do they correctly correspond with the LCA? And When you're working at a client location, it creates a more difficult situation, obviously, because you don't have control of the client or what the client's going to say. If it's in-house, you have a little bit more sway, or you're on top of the situation. So that being said, if it is an in-client situation, I think this is something that everyone needs to start to be aware of, and I'll sneak it in here just so it's something that I make sure that we have brought up. We are now seeing officers ask the client how many years of experience are needed for the position that's being done with them, with the client. So why would the officer ask that? And I actually had an opportunity on a call this week to ask the officer, because what I didn't understand was, what does it matter? What does it matter what the client requires for the position? And he says, well, what we're doing now is we're looking at the years of experience that the client requires for the position, and then we're looking at the level of experience that's required by the employer. And if those numbers don't match, we are asking whether or not the person is working at the wrong wage level on the LCA. So let's say a hypothetical. Employer hires a guy to do a job. The hiring material, the job offer, says the position requires 2 years of experience. Person is placed at a project with Google. Google says that the position requires 6 years of experience. Well, if the employer filed that position using a level 1 LCA because they said the position requires 0 to 2 years of experience, now we've opened the door for USCIS to come back and say, well, the client is the party that's ultimately receiving services, and the client requires 6 years for the position. 6 years looks more akin to a level 2 or even a level 3 position. This person's being underpaid because the LCA is improperly filed. And so you could sit there and say, well, that's good because, they're properly enforcing wage levels. And that's helpful to even the beneficiary, because the beneficiary is going to benefit from this. They're going to have to file a new LCA and pay the guy more. No, that's not the intent. The intent is to issue a notice of intent to revoke, claiming that there's a fundamental deficiency in the LCA, meaning that there's been the commission of fraud or misrepresentation. The beneficiary is not going to benefit from that, and that the beneficiary is going to end up getting a fraud claim attached to them on subsequent filings. So all of that is to say, if you don't have an attorney, you're not aware that these are the kind of things that they're doing. You're not aware that these are their tactics or their underlying justifications for asking the questions they're asking. And also, you're probably not aware that you don't have to give them the job posting, because the job posting isn't a part of the petition. You've stated in the petition that the LCA and the support letter have the information needed, but you don't realize it, and then you just handed over evidence that could end up being problematic. And so, yeah, I would say my conclusion is, if you're going to go it alone without representation in this day and era, I think it's definitely dangerous. But if you do, you need to make sure that your employee has been prepped on what to say, and that the information corresponds with what's in the petition, and that he or she knows who the people are that they are supposed to direct the officers to.
Right. I mean, it's crazy, and it's very tricky, because if you look at it, you may just fall into trap, right? So to be out of it, I think it's always best to have an attorney or a representative for you. So, yeah, thank you so much, Justin, for the detailed explanation.
Mm-hmm.
And folks, yes, if you do want to contact or have a one-on-one consultation with attorney Justin Rivera, go check out this link that is displayed on the screen. And with that, I would also like to say hello to Cynthia, Ricky, and thank you so much, Ricky, once again. Selomit, for your questions. We will take them up. Just stay with us. So, yes, getting very interesting, Justin. Let's move on to my next question that I have for you. So, what kind of documents should employers have ready in case of these sorts of sudden inspection?
What kind of documents should employers have ready? Employers should be ready to produce obviously the petition, the labor condition application, the PAF, the public access file, um, and be ready to be asked questions about the individual's work, who they report to, How they report, that's something that's now being questioned a lot. Are you doing timesheets? Are you doing monthly reports and check-ins? Really, what is being looked at now is how are you functioning as the employer as it relates to running this person's payroll, and how do you know that they're working the amount of hours that they're supposed to be working and doing the job they're supposed to be doing? The thing about it, which is interesting, is that what's really interesting about it is the employer-employee relationship is gone. It's not something that's no longer that exists in the regulations moving forward, but they're still asking questions about it. And again, that's something that you can push back on if you know it, but if you don't, you're sitting there providing information. I'm assuming that they're doing it because, again, the name of the game is fraud, and they want to try and find some way that the employer or employee is making a misrepresentation. But yeah, you need a copy of the petition. I'd have the approval notice. I would have the LCA, the public access file. If you are working in a client situation with vendors, etc., probably have a copy of the most recent purchase order as well, just to show that the project is ongoing, because bona fide job offer is the other big thing they're looking at is, can you prove that this is something that is actually going on now and is going to continue to go on in the future?
All right. Well, thank you so much, Justin, for taking that up. And I think we should quickly take up some of the questions from our audience as well. So let's do that. This first one is from Cynthia. During the inspection, who exactly comes to the work site? Is it just government officers, or could there be other people involved? Am I answerable to the questions asked, or I have options to be quiet?
So yeah, when typically the way it's done is you get an FDNS officer, one officer or two officers, and they're usually going to show up and say, "I'm here for a site visit. I need to see person X," and then from there they get an opportunity to go before person X and talk to them. Here is where your answer is contingent upon whether or not you have legal representation. If you have legal representation, it's permissible for you to say, I'm represented by an attorney. Here's a copy of my form G28. Everything needs to be funneled through them. If you don't have legal representation, if you're saying, I'm not going to talk, I'm not going to do anything, the issue there becomes the FDNS site visits are now mandatory. They're no longer voluntary. Beforehand, you could just say, I'm not going to do this, and you're done. You don't have to put any skin in the game or say or do anything. Now, it wasn't always the best thing to do because, you can walk a line between non-compliance and not fully participating, but the completely not saying anything, immediately they're going to say you're non-compliant. So in today's age where it's mandatory to participate, if you're completely non-compliant, you may open yourself up there to getting some sort of notice, NOIR related to the case, due to non-compliance that has triggered them to issue an NOIR because they have some derogatory information that you wouldn't help them assess or verify. Legally, yes, you cannot talk. You have a right against self-incrimination. So you can legally not say anything, but if you do that, you are kind of opening yourself up. I think that the way to toe the line between the two would be to answer, basic questions about, where you're working, what you're doing, what your job duties are. And then if it becomes more of an extrapolated thing where they're asking, 14, 15 questions, they're asking for a bunch of different documents, I think that's when you push down and say, look, I don't have time to do this right now, or I would like to participate, but I have something, that I need to do. And please send me these requests via email, and I will do my best to accommodate you in a timely fashion. Something like that gives you a little bit of leeway, that doesn't show full non-compliance, is probably the best way to kind of skirt the line. But yeah, at the end of the day, I don't think I would advise someone that doesn't have a G28 to not say anything. I would say what you really should be doing is, and I understand it's self-serving because I'm an attorney, but I'm saying generally speaking, even if it's not me as your attorney, the best course of action is to have a G28, hand it over, and say, I don't have to talk to you anymore because I have an attorney.
It's interesting, yes. And there's sort of a very thin line, right? So friends do not fall into that trap. And yes, always, I think, have that representative. Prepare yourself, especially if you're the employee, you have your whole office there, you have someone to represent or who is answerable, who is properly, knowledgeable to be answering to all these officers. So thank you so much, Cynthia, for that very important question. And let's move on now to Ricky's question. Ricky's asking, there is a site inspection, and should one not say or give anything until the company legal representative available alongside? Tom?
I think we were breaking up a little bit there. But I can read the question.
Oh, I'm so
I
sorry. All right. So I was saying Ricky's question is almost similar to Cynthia's. So he's asking if there's a site inspection, should one say or give anything until the company's legal representative is available alongside?
So I think you can make that argument if you're represented by counsel that's locally available, because then you can say, "Look, I'm waiting till my attorney gets here to say anything." Thing about that is, immigration law it allows for anyone like that's barred in a state to practice. So you have a lot of circumstances where somebody who, let's say, is in New York is represented by an attorney in Florida. Well, your Florida attorney, unless you're going to cut them a very big check, is not going to fly up to New York to sit down with you for a site visit, questioning. So the way that you deal with that is, instead of saying my legal representative needs to be physically present here for us to have a discussion, what you say is, I'm represented by counsel. My counsel is going to be taking over, answering any of your questions, and if I am needed in any way, I can communicate via email or on a phone call that my counsel is present on as well.
Okay. Well, Ricky has more questions, and Ricky, I would just say, please stay with us. I will take up more questions, and thank you so much, Justin, for taking that up. And let's quickly take up cello myths as well. In the event of an H-1B worksite inspection, what are the rights and responsibilities of employers, employees, and inspectors? And how can employers ensure that they are cooperating fully with the inspection while also protecting their interests and those of their employees?
So the way it works is like this. The FDNS investigation, as I've said a couple times, is now a mandatory thing, participation. You have to participate. If not, you get labeled as non-compliant. There's not really fully an understanding of what the impact of being labeled as non-compliant is. I would assume it's going to trigger a notice of intent to revoke on the petition, saying that they weren't able to verify information, something of that effect. So the employer and the employee should participate. Now, the level of participation should be rationally related to the individual petition of the beneficiary that is at issue. So, for example, to give you a little bit of an understanding of that, what I mean is this. If I'm an officer and I'm conducting a site visit, I need to say, I am here to conduct a site visit in relation to petition IOE, 080872, whatever. So the receipt number that is associated with the petition that it is they're asking questions about. Now you say, okay, I'm the petitioner. I filed that petition. What are your questions? And from that point, the questions that should be asked are questions about this person's petition. It should not be things like, give us your payroll records for the past 3 years. Give us a copy of everybody that works for your company that's on an H-1B. Those are not within the realm of the scope of that individual petition. What the officers try to do is use a participating employer or employee as a entry point into obtaining as much information that they can about the organization. They're going to take that information about the organization, take it back to their coworkers and say, what can we comb through here to find something, to find some way that we can pin fraud or misrepresentation against this company? And that's the line that has to be towed, is the employer does need to cooperate, But the employer also can understand that the cooperation can be within reasonable parameters. So you are not obligated to answer every question that's asked by the officer. You're not obligated to produce every piece of information that they are requesting. You are required to participate. And what participation looks like is you are giving the things that are asked for that are related to the petition. If you go outside of that scope, like let's say hypothetically, you're like, I don't care. I have nothing to hide. I'm just going to turn over everything to them. We're a legit company. I'm not worried about it. That's your choice. But I will tell you from personal experience that I had a very compliant client that worked, they were a small company, 30 to 40 employees. That's how they operated with FDNS. They said, look, we have nothing to hide. We're good. We're going to just hand over everything. We're not going to worry about it because we're a legit company. Couple months later, that company is contacted by the Department of Labor, and DOL has been contacted because they have been referred to investigate into the company's pay practices. Now, the allegation was essentially that the company did not pay employees on holidays that were not recognized as federal employee holidays. Basically, what they said was, if you didn't pay somebody on this holiday that the government recognizes as a holiday, then you committed a violation. And so my company, who has complied in as much a way as they possibly believe they can and thinks that they've done everything right, now gets into a DOL investigation where in order to get out of the investigation, they have to go back and pay penalties out as fees to each employee for these days that they were supposedly needing to pay for. Now, remove from that the fact that this employer paid everybody the LCA wage that they were supposed to. They produced proof that they paid all of these people the wages from it. And just look at the end game of it. They furbished documentation information to USCIS outside the scope of the petition. USCIS compiles that information, looks at it, and says, we can't find anything on them really. What else can we do? They either proactively contact DOL or share that information with DOL and say, look through this and see if there's something you can find. But it comes back to the same thing. At the end of the day, their goal is to get something out of you that they can use to either revoke the petition or penalize the company. And so you have to be able, if you're not going to use an attorney, to toe a very, very dangerous line between what is participation and what isn't.
Thank you so much, Justin, for taking that up. And thank you, Salomit, as well. So, very interesting questions we're having today. We got Christopher also join us, and Cynthia says, thanks a lot, Justin. So,
You're
thank you
welcome.
too, Cynthia. We'll take up Christopher's. What are the potential consequences of an employer if they are found to have engaged in benching or unauthorized employment of an H-1B employee during a work site inspection? And how can they take corrective action?
Okay. I think right now we need to make a distinction with benching. Benching is where you have somebody off project that is still being paid in compliance with the LCA. Benching isn't illegal. It's appropriate if you are saying, I have employee X in between projects and I want to assign them to another project. In the interim, I'm going to continue paying their salary in compliance with the LCA, and then I will file an amendment as needed, unless an amendment's not needed because they have a new project in the same metropolitan statistical area. That isn't illegal. What is illegal is benching without pay, because benching without pay is a violation of the petition and the LCA. When you sign the petition, you say, I am going to comply with everything that's in this petition. Part of what's in that petition is I'm paying this person X amount of money. And that's what you put on the LCA, which is for DOL, and that's what you put in the petition, which is for USCIS. If you bench without pay and you're caught benching without pay, the first thing you need to do is go pay the employee the money that you should have paid them, because you're going to be under the eye of DOL. if that information is discovered. Secondly, you need to know that benching someone without pay, if caught in an FD&S investigation, is almost certainly a notice of intent to revoke scenario, because now they're going to come back and say, well, this person's not really working. Why is this petition still in existence? Why hasn't this been revoked? And you're going to have to deal with that at the NOIR stage, where you're going to have to hire an attorney to put some sort of argument together explaining that you went back and paid them after realizing it was a mistake that they weren't paid, and that you've moved them to this project, something. But that's usually what the issue is going to be with benching. Unauthorized employment is, like I was talking about earlier, unauthorized employment previously was something where it would be, well, you go file the amendment. You correct the action on the case. You make sure that the individual's working in compliance with the properly filed H-1B petition. And you hope that that's sufficient for USCIS to say, okay, no harm, no foul. They're going to try to revoke the previous petition. And at that point you say, well, he's on this petition now. Here's proof. Here's the filing. We've moved him over. The oversight has been corrected. The issue now is FD&S and through USCIS is trying to now make an argument that unauthorized employment is a grounds for fraud or misrepresentation finding. Basically saying, your failure to comply with the petition when you've signed the LCA and you've signed the petition amounts to a finding of fraud, because this person's not where they're supposed to be and they're not doing what they're supposed to be doing. That is, like I said earlier, a much more dangerous situation, because there are penalties that can occur for the employer and for the employee. That's its whole other thing with the unauthorized employment. If you're caught in either of those circumstances, the consequence of that is going to likely be action from USCIS to revoke the petition, and potentially action from DOL.
Well, thank you so much for taking that up for Christopher. And Christopher, thank you for your question. Thank you for participating. And I hope you got your answer. So, friends, please do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And I hope that you're resonating with what discussions we are, this topic we are discussing today with Attorney Justin Rivera. And please feel free to also contact him, and the details. In fact, the link is here on the screen where you can contact him. So thank you so much, everyone, already. And we do have more questions. So, Justin, I think my next question to you would be, if an employee works at a client site, what paperwork should be available to prove they're performing H-1B approved duties?
It really just has to be the information that's in the petition. That's what they're entitled to. If you're the employee, if you're the employee, you're basically saying, I'm doing the work that is, within the information provided in the support letter for the petition. And it complies with the, is the information correct and accurate as reflected in the LCA and the support letter. So in terms of paperwork, it's really not much. I would say the petition probably. Now, that being said, what really matters during that site visit isn't the paperwork, which, like I've gone over, is the approval notice, hopefully a copy of the petition, the LCA, that stuff. It's really the statements of the employee, because when the employee is talking to an FD&S officer without an attorney or the employer present, the FD&S officer has the opportunity to confuse the employee, to ask leading questions to the employee because they're trying to get derogatory information, and in those circumstances that interaction can become dangerous. One example that I can give to you guys, which I've told before but I'll tell very quickly right now, is we had to work with somebody to get their fraud finding removed so that they could come back into the United States. And the whole impetus of it was, when the officer spoke to them, they spoke to them about the wrong petition. So the officer didn't explain what petition he was talking about. So when the employee was answering, the answers were all for a different petition. And so the officer's not sitting there correcting him saying, oh, yeah, wait, just to be certain, I'm talking about this. No, the officer's sitting there going, Okay, fantastic. Because they're writing their notes saying, I've got him. I'm going to get this person for fraud and misrepresentation. So it's really about, if you're going to go it alone, sans attorney, you need to have coached your employee. Your employee needs to understand what it is they need to say, and at what point they need to say, all right, I'm done. We're gonna do the rest of this on the phone or via email. And truthfully, I have to say, and again, I admit it is entirely self-serving, but I think it is very dangerous to go this alone anymore. We have seen the increase with the site visits beginning to really ramp up. I think they're going to ramp up much more once we get into late summer, getting closer to that October 1st start date for the new H-1Bs. And I think that people that are not represented by counsel are putting themselves at a disadvantage. And if you decide not to be represented by counsel, you need to be aware of the fact that it is a lot easier for them to work backwards to get the information that they're going to want out of you versus out of having to go through your attorney. So yeah, if you're going to tell them, you're working at the end client, my employee, you need to put some sort of packet together for them that basically says, these are the documents that you should turn over to the officer during the site visit. And if they want anything else, they need to reach out to the employer or, talk to you via email or set up a call with everybody.
Okay. Okay. Thank you so much, Justin, for taking that up and for the detailed explanation. Well, we do have our Facebook questions as well, but are also case studies. So let's take up this case study first. An IT consulting company places an H-1B employee at a third party site but doesn't update the LCA or keep the client contract on file. A USCIS officer visits unannounced. What issues could arise from this situation?
I mean, that's exactly what they're looking for right now. That's what they're hoping. That's kind of a golden goose for them, because right now you're saying, yeah, you're basically saying this person's performing unauthorized work. We've moved them to another location. They're operating in violation of their previous LCA, and they are operating in violation of the petition. So, like we talked about earlier, you have a possible DOL issue if the person's wages aren't higher than what they're supposed to be in that area of intended employment, and you have a possible USCIS issue with the revocation of the petition for the performance of unauthorized work. Carried in with all of that, you now have the door open for them to allege fraud or misrepresentation in relation to the original petition. So yeah, I mean, that's pretty much every bad thing that they have the ability to do, they have in that situation. And that's why, with my clients, I have really told them before, and I cannot stress this enough. The era of holding off on amendment filings is over. The era of saying, we'll move the person there and we'll wait till they get past the probationary period of the project and then we'll file the amendment, that is over. Because here's the other part of it. If you have someone working at a client location, FDNS can and will talk to the client. And that client is going to tell them what happened. So if that guy joined 60 days before the amendment was filed and they find that out from the client, they've got you. You don't have a comeback to that. There's nothing for you to do there. So you have to keep everything in order now. It's no longer an issue of, we'll get to it or it's on our HR's to-do list. People need to understand, over the past few weeks, both the FBI and the DOJ have been instructed to increase enforcement in immigration. Okay? I'm going to tell you guys right now, FBI agents aren't running to the border to help turn people around, okay? What they're going to likely do is say, what are the easiest things that we can go after to show compliance? And one of the easiest things for them to do is work with USCIS and work with ICE to find evidence of visa fraud. And that means that, look, what you guys have been dealing with these past couple of years, it's second tier enforcement. These are enforcement agencies that are, they're given tools and methodologies, but these aren't people that were trained, they didn't go through an FBI academy. They don't have years of service doing investigations. That is what exists in the top tier. And that top tier has now been tapped and said, look into this, see what's going on here. So it's just not the same game it was. And FDNS and their site visits are always going to be problematic because they want to hit you for visa fraud. What is going to be a bigger issue now is, do we start seeing agency cooperation? Do we start seeing more referrals for criminal investigation? Do we start seeing an increase in the FBI finding justifications when they see a pattern of misbehavior for stepping in and opening investigations? All of that is on the table now. So yeah, this person in this situation, I would say you're in a world of trouble. You need to file an amendment ASAP to try to correct everything. And then you need to be willing to provide that information to USCIS when it's requested. But there's a lot of negative fallout that's going to come from that.
Thank you so much, Justin. And yes, there's a lot of scrutiny happening, and we really hope that everybody's safe, and make sure that you have your documents in place and you know that you're on status. And thank you so much, Justin. So far, so good. We do have more questions from our Facebook groups. So, Control, if you can please display them, it'll be great. We'll take up a few and let's keep them brief, if that's fine with you, Justin.
Yeah, sure.
So this first one is from an anonymous participant asking, "Hi everyone, I'm holding a valid F1 visa. I studied the first semester at the university in Texas. Then I transferred to community college in Texas. I plan to travel outside the US. My CVS ID is transferred to the new school and it's still the same number CVS. Should I re-enter the US with a new I-120, new school and old school name on visa? Is it okay? Like, I'm afraid that the school name on visa doesn't match the name school on I-120. So I can't enter the US anymore. Thanks so much for your help."
Yeah, my understanding has always been that the F1 visa is school specific. So what I mean by that is, if you're going to enter the US and attend that school and then transfer to another school, it's permissible. Meaning if you transfer, you get your new Sevis and everything like that, and you're able to stay in. But my issue there, it becomes, if you depart the United States and you've changed the school and then you come back into the United States, what happens if you are questioned by CBP? And if CBP questions you and sees your I-20 and sees that it is a university that is different from what is on the visa, is that enough for them to then say, we're going to cancel the visa because you're not attending that school? To be honest with you, I think it's more of a gray area. And that in a traditional setting, it may have been something that you could sneak by under the radar. Probably something that it's not, when you come in, they're saying, look, they've got a valid Sevis, they've got their F1 visa, they're fine. They can come into the United States, right? What I worry about now is because it is school specific, the F1 visa, I do worry that it could create issues with CBP. So I would be very cautious about it. Alternatively, obviously, we know that the H-1B visa, it's not employer specific. As long as you enter with the original employer, you can transfer and you can go in and out as long as as long as the visa is still valid. My fear is that, look, let's just call it what it is. The F1 visa has been targeted pretty heavily over the first couple months of the Trump administration. They've gone through this thing where they've terminated people in Sevis for pretty much no reason. They've canceled people's visas for no reason. And we're aware of the fact that they have increased the refusals of F1 visas at consulates. So while I would say that I can't on its face say that it's impermissible, I would lean towards the idea that it's a good idea to get a new F1 visa that reflects the school, even if that's not necessarily required. So that would be my general advice on the matter.
Thank you, Justin. And let's go on to our next one now. This is my F1 visa rejected or what? Number one, I'm fully self funded. Number two, I have already B1, B2 valid visa but don't visit USA. Please give me a suggestion.
Okay, so I think what he's saying is his F1 visa was rejected, and he's asking what the basis was of the
Yeah.
rejection. Uh, guess what? They don't have to tell you. The state, if they revoke your visa, all they got to do is shoot you an email saying it's been revoked. They don't have to explain anything to you. Um, you don't have another course of action, to be completely honest, other than to um, go apply for a new visa. And when you're at the visa interview, ask them what the basis of the revocation was. Outside of that, you really don't have anything to go off of. I had an individual um, last month who got their H-1B visa approved and was traveling to the United States, and they were stopped in Qatar, I believe. And they were stopped in Qatar and told that the visa was no longer valid. And they were not allowed to get on the plane to go to the United States. That person, to this day, has not been told why the visa was revoked. We had to work backwards and realize that he was one of the people whose services had been terminated and that his F1 visa had been canceled. And they apparently used that as a pretense to cancel all visas associated with him, meaning his H-1B included. What's incredible about this is the SEVIS termination happened while the consulate had his passport. So the SEVIS termination happens. 4 days go by. The consulate issues his approved visa. And then he travels the following week and is told in Qatar that his visa is canceled. So all that is to tell you, they don't have to give you an explanation outside of we're saying it's been canceled. And then you don't have recourse other than applying for a new visa. To this day, there does not exist any mechanism to uncancel a visa. There is nothing out there that says, using this procedure, the State Department can go back and say the visa we canceled is being turned back on. There's nothing to do that. There's nothing that sits there that allows them to do that. So yeah, I don't know why your visa was rejected. Your visa was rejected. If your visa was canceled, you don't have any recourse. If your visa was rejected, meaning that you were at the consulate and the email and sorry, you're at the consulate, you applied, and then they handed you a visa refusal, you need to look at the basis of the refusal. The refusal is going to list a justification. Now, 9 times out of 10, what I've been hearing is that justification is now 214B. So 214B says your activities do not comply with the visa that is being requested. What does a 214B mean specifically? Okay, I'm signing up for an F1 visa. I'm going in for an interview. I have to show that I have non-immigrant intent. You have a presumption of immigrant intent because America is so high and mighty that they believe that anybody that comes into our country by default wants to stay here, which do with that information what you want. However, you have to work to prove to the officer that that's not the case, that you have a firm timeline, that you're going to accomplish a task that is permissible by your visa, and that at the end of that task, you will depart the United States. How do you show that? You show that you are going to comply with the visa. I'm going to attend school here. I'm going to do X. I'm going to go for this degree. Here's where I live. It's by the school. All of that's fine. But you also have to show that you have those ties to your home country that will prevent you from immigrating permanently. Well, when you're a college-age kid, how do you show ties? You got to show them through your family because your parents are the ones that own the house or the apartment. It's not you, So your ties are typically shown through that. Your family is in that country. Your family is, they're going to live there. They don't have an intent to immigrate themselves. And when you're done studying, you're going to go back go back to your country, your family. So what I see happening now more and more with these F1s is 214B coming into play because the individual has a U.S. relative. And are they using that U.S. relative as a pretense to claim that there is immigrant intent? There's not definitive data to back that up. It's just my, tinfoil hat theory of why are they using that as a justification. So that's one thing to look at. Look at the reason for the refusal. Luckily, the consulate has to give you a reason. And then that reason is going to be what you track backwards and determine, if I apply again, what are the changes I'm going to make.
Very interesting. Thank you so much, Justin, for taking that up as well. And well, we have more questions. If I think let's take this last one. So this is saying, "Hi all, just wondering if anyone here has recently gone through the visa renewal process at the Paris embassy. My visa expired recently and I'm trying to decide whether to travel this summer. I'm French, planning to go home. I've qualified for the interview waiver, but I'd love to hear how things are going now, how long it took, any issues, etc. Just to make an informed decision. For context, I am fully funded PhD student at the UC Berkeley with a GSI appointment. Got my MA at CU Boulder last year. No law enforcement issues. I usually go home every summer to see family and hope to do the same this year. Thanks in advance for sharing your experience."
So, I don't have words about the French embassy specifically, as I have not attended a visa interview in France ever in my life, because I don't need to. But I've also never even been to Paris, or at all.
Me
Great
too.
job with the Olympics, though; those were fantastic. Um, I would say this: 95% of immigration attorneys that you're talking to right now are going to tell you that you shouldn't travel if it's non-essential travel. I know that there is this idea that, the immigration attorneys are, boogeymen who are creating this false sense of fear because they don't want that. That's not true. We are by nature trying to put you on a path that has the least amount of risk associated with it. Anything that elevates risk is problematic for us as an attorney because we want to make sure that you are able to do the thing you want to do, which for somebody that's on a visa in the United States is usually to live here and or to work here or to go to school here or whatever. So when we say we don't recommend traveling unless it's essential, that's what we mean. There are two barriers to entry for individuals who are getting new visas into the United States at this point. The first issue is the consulate. The consulate, that all of them writ large, the consulates have been told to perform enhanced vetting on visa applications, meaning anyone that's applying for a visa is going to be looked at with a more stringent line than they were previously. What does that mean for a normal person that, they've never been arrested, they've always complied with their visa? It should mean nothing. It should mean that person's completely fine. But if you are going to renew your visa, you now have to, look at, have you ever said anything on social media that was negative towards the United States or Israel now, apparently? Have you ever liked a comment that someone else made that could be construed as negative? Have you ever said anything in an Instagram post or whatever? I don't do social media, so I don't know any of that stuff. But is there anything there that they could latch onto to make problematic? Let's say no, there's nothing. Okay, good for you. You should be okay to travel abroad and get a visa. You go abroad, you get the visa, you think, awesome, my visa's back. It's time to go back to the United States. Okay, welcome to barrier number 2, CBP. CBP, since the change of the administration, has gone from an entity where they're doing their job, they're looking at docs. If you have something previously on your immigration history, you might get put in secondary inspection. CBP now is an aggressive actor, for lack of a better term. CBP now is saying, do we have the ability to cancel people's visas coming in and put them in expedited removal? Because once we do that, they count towards the 1 million deportation goal. And that's who you're handling at this point. They're not the same. It's not the same as it was before. Now, look, can you go get your visa and you're squeaky clean and come back into the United States and you're squeaky clean and they look at your passport and they let you walk right in? Absolutely. It can happen. But in an era where our job is to define risk for you, there is going to be risk at a higher tier than there ever was previously with re-entering. CBP can and will utilize this opportunity as a chance to review your entire immigration history and to put you in a room with CBP officers. Uh, you do not have a right to counsel when you are speaking with CBP because you have not been admitted to the United States. CBP can and will put individuals in secondary inspection for hours. They will question you with different officers. They will question you with multiple officers. And they will question you and make statements that are not true because their end goal is to cancel the visa and have you removed. So, why I say this is you can go do that. You can get your visa renewed. You can come back and you can be completely fine. It can happen. But there is more individuals getting their visas canceled than I have ever seen in my history practicing now than there has ever been before. So I think it's dangerous. There's a level of danger to it. Ask the kids who came in to Hawaii to go on vacation a couple months ago who had their B2 visas canceled because they said to the CBP officer, we like to do freelance work back in Europe. That was it. That was all they needed. They said, okay, they like to do freelance work back in Europe. They're going to be working here. Visas canceled. And that's it. That's all it took. So yeah, I would say, yes, you can do it. Be prepared. Probably talk to an attorney beforehand. If you're not talking to an attorney at the consulate before you go for the interview, that's up to you. I would very much say, though, talk to somebody before you come back into the United States. Because if you haven't traveled abroad yet and re-entered, you are not aware that this is a different animal than it was before. So yeah, you're probably fine. But I've seen the horror stories. I've seen the cases that are terrible. I've seen the people detained for over 24 hours at an airport that have had their visas canceled and been put on flights the next day back to their home countries. So I would just say be cautious.
Thank you. Thank you so much, Justin, for, taking that up and explaining it so thoroughly. It was really nice how you made it sound like the different levels in a game, Welcome to obstacle one and then two. And well, that is really happening. It's nothing to, nothing too amusing, but it's really happening. I think knowledge is power. So I would say, keep yourself updated and just like Justin has said, consult with an attorney, and if you do want to consult with attorney Justin Rivera, please check out the link that's displayed on the screen. And yes, don't forget to subscribe to our channel because we come up with the latest updates for you also. And our handle is at Immigration Talk Show. And I think with that, Justin, we will wrap up our session for today. It's really wonderful how you patiently answered and took up each of our questions. You know, very interesting how you answered them as well. Very insightful session today indeed. Thank you.
Awesome. Yeah. Thank you guys very much for your time. Have a wonderful weekend. Everybody enjoy the 3-day weekend. I'll talk to you again soon.
You too, Justin. Happy weekend.
All right. Bye.
Bye bye. And folks out there, thank you once again for joining us. And if you do have more questions, please feel free to keep commenting. And also, you can WhatsApp me or call me on my number in case you have more questions. My number is 408-335-6444, and my email address is nipa@staffingly.com. And I would just say stay tuned on Immigration Talk Show because we have so much more coming in and for latest update on everything US immigration. So thank you once again, everyone, for tuning in. Don't forget to subscribe. Our handle is at Immigration Talk Show and hit that bell icon so that you will be notified whenever we have discussions like these. So bye for now. Have a wonderful day and see you very soon.